the link. I will also pin Rachel. Fabulous, Rachel, if you don't mind to introduce yourself and then discuss the topic at hand.
Absolutely, yes. Hi there, everybody. So my name is Rachel Harkin. I am the head of the legal advice service at ILG Support, which is part of the Independent Living Group Limited sequence of services that we provide. We offer our legal advice, which is included in the Mark Bates Limited insurance policy. I have been involved with advising individual employers like yourselves for 15 years, very, very, very long time. Or it feels like a very, very long time. And I have also managed a direct payment myself for my sister, who was unable to manage her own budget and required around the clock support. So come at this not only from a legal perspective, but also from a practical, real world, genuine knowledge, and have a lot of experience. So if you have any questions, please feel free to bank them and we'll discuss them once I've covered the core elements of the subject. What we're going to look at today is maternity and paternity leave. I haven't got any slides prepared for you, but we do have all sorts of information in ILG. We have different guide notes that break down these rights, and it is certainly information I would happily share with you later. I can email it out to you if you wish to have that information, not a problem at all. So, what is maternity and paternity leave? These are essentially statutory rights. One of the things I often say to employers who perhaps new to the concept of law and how and why it applies to them is when we think about employment law, unlike let's say a business to business arrangement where we have a contract that can be negotiated and whatever terms those two parties agree, they're pretty much free to do so. When it comes to employment law, it's rather different because the government take a significant interest in employment rights. And that's for a couple of reasons. Of course, it's to ensure that commerce keeps flowing. So the right employees are going into the right jobs, that businesses are flourishing, but at the same time, there is a distinct interest in protecting employees' rights and ensuring that we have a base level of accepted service that workers are obliged to provide to employers, and that there are certain protections in place. So maternity and paternity leave provisions very much fall into that camp of what our government, what our society, in fact, what all of Europe require employers to provide when people become new parents. We are a little bit behind in the UK in terms of paternity rights. They are rather more limited. So paternity rights, and I've got to be honest with you, they tend to come up a lot less for me and my team when advising individual employers. In the most part, the inquiries do come in about maternity leave. Presumably there's less men who are working as PAs. But paternity leave rights are really quite small. A man is entitled to only 2 weeks, up to 2 weeks of paternity leave and pay. Okay? Be aware that sometimes there is a difference between leave and pay. So in order to qualify for pay, the person has got to have been employed. This is both maternity and paternity pay. It's a statutory amount that is set by the government, and in order to qualify, the individuals must have been employed for 26 weeks. This is with this employer, 26 weeks prior to what they call the qualifying week. So the qualifying week is the week which is 15 weeks prior to the expected week of childbirth. So we can see that for a PA to qualify either for maternity or paternity leave, they must have been employed for quite some time. Leave, of course, is slightly different. And a mother is always going to have the right to take her maternity leave, just not necessarily the right to maternity pay. Okay. Now, when we're thinking about what maternity leave is, unlike the male who only gets up to 2 weeks, a mother who is going on maternity leave is entitled to a full year of leave. It's broken down into two different parts. I won't bore you with the details because in truth and practice it's not really relevant, but it's a full leave year that she's entitled to. Often she will not take a full year because statutory maternity pay is actually limited to 39 weeks. So that's 9 months. So the leave and the pay are different. We've got a full year of leave they're entitled to, but only 39 weeks of statutory maternity pay. Maternity pay again has a qualifying criteria, exactly the same as paternity pay, sorry. So that means that she must, in order to qualify for statutory maternity pay, the mother must have worked for the employer for 26 continuous weeks. So when I say continuous, I mean it doesn't apply to a casual worker. She must be an employee consistently employed for 26 weeks prior to that qualifying week. And a reminder again, qualifying week is 15 weeks prior to the expected week of childbirth. Statutory maternity pay is only applicable to parents, both maternity and paternity pay, if those workers have earned an average of £125 per week during this qualifying period. It's an 8-week period, sort of midway through the pregnancy, let's say. They must have earned that on average. So if you've got workers who are only earning, let's say, £50 because they're coming and doing a couple of hours a week for you, then they're not going to qualify. And you would then rightfully say to them, I don't have to give you your statutory maternity or paternity pay. You can claim whatever allowances may or may not be available from the government, but you, the employer, would not have to pay it. So that eligibility criteria is strict. When thinking about what is statutory maternity and paternity pay, that changes every year. So currently, the maternity and paternity pay that is achievable is £187.18 per week. Okay? If the worker has been earning less than that, so let's say they're not earning £250, they're actually maybe earning £130, then what they're entitled to is 90% of their normal pay. So it does go down, recognizing the lower amount of the payment that they're used to earning. So, I've just said to you that they've got to have earned on average £125 per week. That doesn't suddenly mean that when they're on their maternity pay period that they're getting 187. It's not going to be that. It's going to be 90% of the amount they're used to earning. Something that I think is really critical to mention while we've got an opportunity to talk in an environment like this is that if the employee is entitled to statutory maternity pay, that eligibility it's absolute. So even if you go through a period where, let's say, for example, the PA resigns, or let's say you even something as extreme as dismissing the PA for gross misconduct, so long as she's hit that eligibility criteria, you are obliged to pay statutory maternity pay. Okay? Now, often in a scenario like that, if the employment has completely terminated and you're going to want to bring payroll to an end, what is often possible, and I would advise you to check in with payroll under those circumstances, payroll would put an application into the revenue to have the whole lot paid in one full swoop. Not always ideal for the worker for various different reasons. It's a big amount, a lump sum payment coming in, but it's certainly easier and cleaner for you. So that is something that you can talk to payroll about. It is sensible for you to check your contracts of employment and any policies that you might have in place when you're looking at a worker who's going to be taking time off. You may well have issued policies that give something a little bit more beneficial. Now, I generally would suspect not. For most individual employers, contracts of employment would have been provided by a support organisation that have been supporting you. It may well be that the local authority has a particularly preferred contract or set of policies that they like to be issued to individual employers in their area. And very often you may even have gotten your contracts and your templates from a service like ours that we would provide. And we generally set out our terms in a way that meets only statutory minimums and tends to actually reference statutory minimums, because each year that average weekly pay, in order to check the eligibility criteria and the amount that is paid for statutory maternity and paternity leave, it goes up. It can go up every year, very often in April. So in your contracts and your policies, it is very common to see that there is simply reference to statutory minimums. Now, of course, you may well be familiar with them in business. It's not uncommon for a business to have greater provisions. There is no reason why an employer can't sort of hit that statutory minimum and pay and do more on top. Of course you can. I would advise you not to be too maverick. If you're wishing to be more generous for your PAs, do make sure that you're checking in with your funding body, because you don't want to suddenly find that you do not have the budget to be as generous as you would like. Okay. If you need any help and support at any point, maybe you've got early days of having somebody who's told you that they're wanting to take this leave, then of course reach out to your legal helpline at any point. You should find that you have a legal helpline in your insurance policy, your employer's liability insurance policy, so do reach out to them. And of course talk to your payroll company or funding body, whomever that may be, to ensure that you've got adequate provisions in place. Now, one of the reasons you're going to want to have adequate provisions in place is because one of the important things that is going to hit you during the course of the pregnancy, before the leave has even commenced, is the worker will be taking, or is likely to be taking, time off for antenatal appointments, which they are entitled to do. And there is no official cap on how many antenatal appointments they have. You can ask for evidence that they have an appointment set, but so long as it is linked to their pregnancy and it has been recommended by either a doctor, nurse, somebody who is involved in their care, then they have the right to take that time off. So yes, you can ask for evidence, but no, you cannot refuse that time off. Now that, of course, is going to have an impact on you practically. During the course of the pregnancy, you're going to want to get alternative cover in place. So you're paying for that hour of time that the worker is away, perhaps twice, because you're getting that second worker in. So from a very early stage, I would advise you to get in touch with your funding body to make sure that you have adequate provisions in place to cover the absence of the worker during the course of the pregnancy itself. And of course, make sure that once the leave has commenced, that you've got adequate funding for your temporary worker, which I'm going to talk about a little more shortly, alongside any of these statutory payments that you're obliged to pay. One of the things I would like to mention at this stage, because it does come up a lot, it may not be relevant to you, but it comes up a lot for us with individual employers, is that there are occasions where during the course of a PA's pregnancy, an employer becomes concerned that they're not able to keep that worker safe. Health and safety is a really critical thing for you to keep in mind. You should be risk assessing at various intervals through the course of the pregnancy, because of course, the PA's condition changes. In the early stages, they may be absolutely, full of energy, absolutely fine to be doing lots of work on their feet, perhaps even any manual handling and so on may be fine for them. But as the pregnancy continues and they get bigger, it may become harder. So a fairly regular risk assessment is important. Again, this is something to keep in mind while you're preempting a possible problem or possible practical concerns that may arise when you have pregnant workers. If you cannot keep that worker safe, and it's about safety, not about them being unwell, because of course unwell happens, but let's talk about safety. You may have to pay that worker not to attend work. Now, again, that can result in the need for double funding. So the sooner you let your funding body know that these are potential concerns, the better. Keeping an eye then on the health and safety of the worker, making sure that you are practically prepared for any constraints that may occur on the budget, and being ready to allow time off for antenatal appointments is really critical for you managing this as safely as you possibly can, and making sure that you are doing everything you can to support the employee's rights. One of the things that I would identify here is that both the mother who is taking leave and also the father who is taking leave, they should be notifying you about at least 15 weeks prior to the expected week of childbirth, that qualifying week that I mentioned. They should be giving you sort of 15 to 11 weeks notice of when they intend to take their leave. Okay. That gives you the chance to prepare for it. So you've got an idea when that leave is likely to start. That can be changed subject to agreement with you, but at least 11 weeks prior to the leave starting or the baby being due to be born, they should be giving you an advance notice. Now, at that point, and this is a critical point that a lot of employers fail to do, you should be writing to the worker to express this is when you're starting, and this is when you are due to end. If you have a definite agreement with a worker that they absolutely are coming back sooner than the 12-month period, let's say in the case of a mum, sooner than the 12-month period is due to end, then state it in that letter. Very commonly, I would get a phone call from somebody who says, I've just not been able to the worker, she was meant to be coming back after 6 months, or she said she was coming. I've even had people saying she was due to come back after a month because she couldn't afford to be off, and now I've not heard anything from her. One of my first questions is going to be, did you put that in writing? And very often the answer to that is no. Okay. It is critical that you do that to demonstrate that you've had those conversations, you know when the clear start date was, you know when they were due back. Now, technically, in the regulations, for a mum to come back sooner than the date that you have agreed, she should be giving you 8 weeks' notice in writing. Okay? You can, of course, change that if you wish to allow her to say, oh, giving you a 2-week notice period for return, and you're happy with that, of course you can. But what it goes to show is that the law recognises you will have arranged cover during her absence. So that is absolutely possible for you to get a cover worker in. Absolutely critical piece of advice is when you are doing so, let's assume you're not getting it simply covered by workers you already have and they're doing extra overtime. Do keep in mind that if you're getting a temporary worker in, temporary is the key. You are able to issue a fixed term contract that stipulates that contract will come to an end when the maternity period that they are covering comes to an end. So it effectively terminates the contract straight away without the need for you to go through any awkward conversations and make it difficult. Fixed term contracts are critical. Something else I want to highlight to you, and again, this can cause you budgetary constraints. Do keep in mind that even when a worker, both the lady who is off on maternity leave and the man who is off on his paternity leave, albeit may only be just 2 weeks, but nevertheless, when they are away from work, they are still accruing annual leave. Okay? Even if she's off for a whole 12 months, she is still accruing annual leave during that time. So you're possibly aware that annual leave is 5.6 weeks per year. That will carry forward so she can use it in the next year. Let's say she comes back at a point where there's just not enough weeks in the year for her to take that leave and be paid for it. You must carry it forward into the next year. Okay? So long as I believe if you are familiar with these rules and you're prepared and organised, you will be able to effectively map out what this period of leave looks like with good communication with your worker, ensuring that you've got an adequate budget in place. You will have a vision for what that looks like. And that will also give you the confidence for taking on any temporary workers that might be needed, who also, of course, are accruing rights to annual leave during that time. So it can give you a really, having this knowledge gives you a good foundation. You know what's happening, you can plan ahead for it, um, and make sure that you've got your budgets in place. Your legal helpline will be able to provide you with any documents that you need. So let's say, for example, the worker is not entitled to a statutory redundancy payment. Sorry, statutory maternity payment. Then they will be able to issue you with the forms that you need in order to declare to the worker why they're not entitled to the payment. And also, I've said to you, put in writing the date that she's going to start, the date that she's coming back. In this letter, you will say things like, if you want to return sooner than this date, you need to give me 8 weeks' notice in writing. Those kind of template letters, your legal helpline will be able to provide you with. If not, any support organisation that you work with who might support you as an employer. Okay. Do keep in mind that a lady is obliged to provide you with evidence of the pregnancy. That comes through in the MAT B1 form. These days, that MAT B1 form tends not to be given to her. This is the declaration from the medical team that says, yes, you are pregnant. That tends not to be given to her now until the 20-week scan. So it's quite some way into the pregnancy. When I had my child, I was given it by the GP just because I'd gone in and said, I think I am. And he went, oh, okay, here you go. Gave me that. That doesn't happen anymore. It now takes a lot of time. It's 20 weeks before you can get it, but that document you absolutely will need because it also supports your application to the revenue to reclaim the statutory maternity pay. Okay. Um, I think that's pretty much it really from me. I've probably talked a bit longer than I was asked to, but that's not uncommon. So if you ever ask me back, maybe give me a little bit more time. But that's as far as I've got. I think the basics covered, and any questions, please feel free.
Thank you very much, Rachel. 1 second, I'll just stop the recording.